So this was an EB-1A. It's for a scientific leader at a pharmaceutical company, a well-known pharmaceutical company. He apparently had talked to his company lawyers, and they work with one of the really big immigration firms. Apparently, the lawyers had advised the company that EB-1A is only available to people if they can confidently say that they are one of the very few scientists at the top of their field, which is actually the wrong legal standard. This was clarified when USCIS passed the regulations that are part of the law. Usually, they include some questions and answers that evidence the intent behind the regulation that they passed. And in those questions and answers, they actually say that the standard was not meant to be restricted to one of the few. They said that they use the term has risen to the top of the field, and is one of that small percentage that has risen to the top of the field for a reason, so that it would be less restrictive than having to prove you are one of like the very few, like one of the top 10 scientists in the field. So we proceeded with the case. This law firm, though, they got really involved in our client's case when he tried to get letters from managers at his company. Even though the letters were not on company letterhead or anything, this immigration firm seemed very invested in going against his EB-1, which I personally do not like. I don't like it when these big firm lawyers interfere with individual cases. I think sometimes they have a chip on their shoulder where they're like, we give the right advice and our advice must be followed. And they're not really open to any kind of creative solution. I've encountered this in the past when working on O1s and EB-1s, where the firm really, really tries to interfere. And it was driving us both absolutely insane. We felt that the managers could not sign off on the true facts of what my client did at the company because the lawyers were uncomfortable with having the managers attest to those facts. But anyways, this case was just approved. I'm so excited for my client. He can finally get his green card. He can probably file for adjustment immediately, even though he's an Indian national, because he had a prior priority date. And I just want to say winning these cases is very satisfying, especially when you have clients who are coming to me and they've said that past firms have denied them or said their case isn't strong or have really insisted to their company that there's no way these cases can get approved. I just really like winning those cases. It shows that a creative approach can work. And not just a creative approach, just being reasonable, and looking reasonably at the law and how the facts can fit within the legal structure. So just wanted to share that story because that was a big win this week.